Hi, everybody. It's Karen Anderson here with Aortic Hope, and I'm so excited for today's live Q&A event. But before we get started, I want to ask everyone to please remember to like and click subscribe on the buttons below, above, wherever you might see your buttons. This way, you'll be notified of all of the live events that we have just like this. But we have a very special event today. This is a topic that I have not yet, in the 7 years that I've been in this community as a survivor, heard anybody discuss this before. It's very important information. This type of stuff needs to be things that we talk about more openly and freely because it's a reality. It happens. Part of living means death. It's a it just is what happens. And we need to discuss the best ways to set up our loved ones and protect ourselves for that transition into the phase of having, passed away. So we're very excited to have from the law offices of Susan Trimble. We have Susan Trimble with us here today. And I'm going to have Susan go ahead and take a minute to tell you a little bit about herself. And then we're going to get into some very interesting information in this PowerPoint presentation. And as you have questions, feel free to put them in and we will talk about them and any other comments you have. But welcome, Susan. Thank you so much.
Thank you, Karen. Hi, my name is Susan Trimble, and I'm a practicing attorney for about 12 years now in Annapolis, Maryland. And a little bit about me. We do run a mobile will service that's local to Maryland only. So if you are in Maryland, or you know anybody who is, feel free to contact me. That little item up there that says bucket list, before I pop my clogs. Popping my clogs is sort of what a slang they have in Britain that says when you pass away, you've popped your clogs. So a little humor there. But anyway, if we could get to the next slide, Karen.
Sure.
I just wanted to mention that this is general advice, that I'm not practicing in any state other than Maryland, but I did want to help everybody have a general understanding of why you need a will or why you don't need a will. If I get to an area that is state specific, or I think might be state specific, meaning I know how we do it in Maryland, but I don't know what your state is, then I will try and point that out. But I'm going to give you a general overview of how you contact an attorney and what they're going to want from you, what the process involves, the first contact, and the procedures. And I'm going to raise some issues you might not have thought about. You know, a lot of people say, well, can I do my own will, or can I download a will off the internet? Well, sure you can. But some of these issues that I'm going to be pointing out to you, you're not going to know unless you're an attorney. You're not going to know that your will might be invalid, that you haven't considered some things, and I'll go through that right now. So go. Yep. The end of life planning is really hard to talk about. And even when people hire me and I send them a questionnaire to fill out, it might be, I've had people get it back to me in a year. I'll get that to you right away. I'll get that to you right away. But it's people just don't want to deal with it. But it's really not that expensive. Once you have it in place, you just need to modify it if things change, and I'll get to that later. But let's go ahead and dive in and start thinking about, how do you get a will? Go.
Okay.
So the word intestacy, it means you die without a will. And that means your state is going to decide where your money goes. And if you could go to the next screen, this is just an example of what, if you see here, if you die with children but no spouse, your children get everything. But let's go down a little further. You might have siblings you don't talk to. You don't want them to get your stuff. So it's something to think about, controlling who gets your assets. And when I think about assets, you know, I'm not just talking about wealthy people. I'm talking about mementos, picture books, even though it's a small thing. You know, I can't tell you how many times I've heard somebody say, well, I never got, you know, the family albums. I never got this picture. My mother even says, oh, there was a picture that used to hang over my mother's bed. I wonder whatever happened to that. Well, she's one of 7 children. So who knows which one of the children got that. And it's small, but it meant something to my mother. She wouldn't be bringing it up year after year. And now she's 86. So, okay. So now here's another consideration. Let's look at this. You want to write a will, and you can certainly write your own will, or you can download it off the internet. What if you say, I want to give X amount to my children? Well, who does that include? We've got a lot of families that are, second marriages, third marriages. When you say, I want to give everything to my children, are you including your stepchildren, your husband or wife's children from a different marriage? Are they children? I don't know. Not in Maryland, but maybe in your state. So you have to think about the adopted children and the stepchildren and whether or not they're considered children when you are giving things away in your will. Also, what is a spouse? In Maryland, we don't recognize civil partnerships. We don't recognize common law marriage, where, for example, when you're married 10 years, you're considered married by state law. Pennsylvania, I don't know if they're like that anymore, but they used to be, I think. But what does your state have? Who is considered a spouse? Who has rights to what you have? That's something that you need to know. If you have something that you want to put in your will, you need somebody to explain that to you, somebody's qualified. So again, this is just an example of how, if you don't have a will, somebody you don't want in your family can end up with your stuff, and not the people you want to have certain things. Go. This is just a little terminology that I'm going to be using, so I thought I'd just run it past you a little bit. The testator is the person that is making the will. The estate. What is an estate? It doesn't mean you're rich again. It means everything that you own is your estate. That means the pencil and pens in your house. That means your clothes. That means your jewelry. Your estate is comprised of everything that you own. It's not comprised of certain things that are exceptions to what's in your estate. And I'll get to that in a minute. Executor, that's the person that you designate to, after you die, take the will, look at it, and make sure that everything you have is collected, categorized, or itemized for practical reasons, but it may also be required in your state by your estate section of your higher court. A lot of people register their wills with their court system, so it's on file. But that court system in your state is also responsible for making sure that the executors follow your wishes. Now, a lot of people might have a will and they give it to somebody, the executor takes it, and they don't even bother filling out the forms they're supposed to with the state and filing to open an estate with the Register of Wills, also called the Orphans Court. That happens quite a bit, but that person runs the risk of creditors coming after them, family members coming after them to file lawsuits against them for not following your wishes. So your estate is everything that you own, and I'll tell you what the exceptions are that don't go into your estate in just a minute. The beneficiary, that's who you give your things to. Who is somebody who's going to receive something, anything under your will, or even a potential beneficiary. So if I give something to my sister, but if she's not alive, to my brother, but if my brother's not alive, then to his daughter. So all of those potential recipients of your assets are considered potential beneficiaries. The residuary estate or residue, that's important, because what you're typically going to do with the will is you're going to say, I want these items to go to my best friend. I want my Waterford crystal to go to my niece. And you list out all the different things that you want to go to specific people. And then everything else is called the residue, the rest and residue. That's whatever you didn't specifically name is everything else. So the rest and residue I give to my 3 children jointly. And so then the executor is going to have to split up everything between the 3 children in a fair way, because once you charge an executor with the responsibility of dividing up your stuff, you trust that person is going to do it in a fair and even way, but there's no guarantee. So you choose wisely, because the residue gets split up by the executor to the beneficiaries in the way that the executor thinks is reasonable. And hopefully that person is going to call the beneficiaries of the residue, call them together and say, is there anything in particular that you want? Let's try and divide this up fairly. So that's why you want to choose your executor wisely. Otherwise, they might just donate everything to charity or take it to the dump. You also want to choose a successor executor in case that person isn't around, or in case they don't want to do it. Maybe they have too much going on in their life. So it's important to name an executor and then a second executor. Now you can name co-executors, but I find in my experience that's probably not a good idea. You want to be fair, and you have 2 children and you want them each to have 50-50 decision making. But what happens 9 times out of 10, if you ask me, is there's going to be arguments, and paperwork isn't going to get processed. Things aren't going to get sold because you need 2 signatures. And those 2 children, even if they get along, one might be in a different state. You just really should choose one executor, in my opinion, but this is a personal decision. And then I already explained what intestate or intestacy means. That means you don't have a will, therefore those laws of your state will determine who gets your stuff. Okay, go. Now, not everybody needs a will if you don't have any assets and you don't have any relatives that might get something. You don't really have to have a will, but these are the things that having a will give you. Again, you will have control by making sure that the people that you want to receive things get them. For example, a lot of people have that one person in their family they're not talking to, or they don't like, or they don't really want getting their things. Every family has different dynamics, and if you have control, if you have a will, you have control, and that's really the main reason why you should have a will, so you can control your assets. But if you have young children, you are able to name in Maryland somebody, if it's not your spouse. Obviously the spouse typically has the right to raise your children if they're minors. But if you don't have a spouse, you get to say in your will who you want to watch your children typically. Now it's not in right, it's not that black and white. A judge has the ultimate decision if it's challenged by anyone into the family court system. So you can recommend somebody, and if it's somebody who is reasonable, and the judge is probably going to rubber stamp it. But ultimately, it is up to a judge. But it's very important that you name somebody that you trust for young children. Also, if somebody is vulnerable and they're dependent on you, or even if they're not dependent on you, let's say one of your family members has always been irresponsible, and I hear that quite a bit, and my clients sort of hedge around it and say, well, my one son, and I know it's coming, or my one daughter, and I know it's coming, because there's always one who, they just haven't found themselves yet, and the money goes in one pocket and out the other. So you can specify in your will that you want them to get that at the age, a certain amount at the age of 25 or 30. Or you can say, I want this person who I'm not quite sure is going to be able to handle the responsibility of having money. I'm going to name their parent, or I'm going to name somebody else that I trust. Maybe the executor can be that person to decide when that person gets that money and when that person's responsible. You can leave it completely up to the executor. You can specify a date. You can say after they graduate from college. You can say they can have this money, but only for college. So it gets back to having control of what you want to give, and maybe making something good happen after you pass away. Maybe provide for somebody's education or partial education, or maintenance, rent, gas, things like that, things that people need. That goes into irresponsible beneficiaries. And I felt it was important to name because, again, I hear that all the time. Somebody's into drugs or what have you. You may not want to give them anything right away. Also, the benefit of making a will is to realize what your assets and liabilities are, because you may own something, but it's owned partially by somebody else. So it's not 100% yours to give away. You may remember that you have a debt that you kind of blew off, maybe a student loan that you haven't paid in a while because it's in forbearance. They're going to come back and with their hand out. So you need to make sure that you consider everything that you have, who owns it, and everything you owe. And if somebody owes you, you can also forgive debts. If somebody's borrowed money, you can say, I'm absolving them of that responsibility. A lot of parents do that with their children. And then tax considerations. And I don't do tax planning, so I can't talk much about that. But you do need to think about that as well, especially if you do have any kind of assets. Go. Also, you can specify if you want to be cremated. You can specify if you want to have a service. One lady I recently helped said she wanted her ashes put in a whiskey barrel. You can do whatever you want. If you have a property in a foreign country, you definitely need to include that, because Lord knows what they have in that country in terms of what the law says, who gets it. It's yours, you control it, you specify who gets it, so that country doesn't impose the decision upon your estate. Business property, if you have something like a charity that you want to keep going after you pass away, who's going to do that? If you run a small business, do you want it to just be wrapped up, or is there somebody you'd like to see carried on for you? And also, you can give gifts to specific people for a specific purpose. One lady said she wanted all of her best friends, there were like 8 of them, to take a lump sum of money and go on the trip of their lives, and she gave it to their discretion what that trip would be. But, you can have a bit of a legacy amongst those you leave behind if you like. Pets, a lot of people know that somebody that they love is going to take care of their pets, but I can tell you my husband doesn't want my dogs after I go. So I'm going to make sure that I'm naming somebody that is going to make sure they're rehomed or take care of them, and I'm going to give them some money to make sure that their veterinary needs are taken care of. So that's important as well. And then really it's important that you talk about your family. Talk with your family about what you decided, even though that's difficult, because maybe there's something they're not telling you that they want, that you don't know that they want that might be important to them. And it's so much better if you have a conversation um, before you die, because nothing should be a big surprise. You don't want to risk having contention as your legacy. You want everybody to be harmonious with the decisions you've made as best as possible. Obviously, nobody can be, it's completely happy sometimes, but you really, I always encourage my clients to um, discuss what you want to give them, what they might want before you do your will, and then after you do your will. Okay, go. The process of making a will is mysterious to those who haven't done it. I'm just going to tell you it's super easy. You call a lawyer if you're not doing it yourself, and you arrange a meeting. And in preparation, you'll just make a list of everything that you have, your house, your investments, your pension, and then your residuary estate. But anything specific you can think of, you should list. Not 9 times out of 10, your attorney is going to send you a questionnaire. It's going to be a general questionnaire. So if you have any specific questions that you don't see or are addressed there, you make a list of your questions. Questionnaires can't be geared towards every single specific person. So don't be put off if the questionnaire talks about, asks you about your grandkids and you don't have grandkids, but it doesn't mention what you something else. So it's just a general questionnaire. And when you're done, if you are wise, you will have done it before your mental capacity might come into question. Some people will contact an attorney when they get a diagnosis, or they're worried about their health. And if that person is older and maybe not as sharp as they used to be, you're going to run into problems because the attorney has an ethical obligation to ensure that you know what you have and you know what you're doing with it in the will, that nobody's pressuring you, and that if you seem a little confused, they may not do the will for you. So you don't want to be, if you have an elderly relative, you don't want to be the family member that's saying, oh, come on, you've got to talk to the lawyer, and then they're a little fuzzy, or there's question as to whether they're fully mentally capable, because at that point it just might be too late to have a will. So that's a good reason for doing this now, not a year from now. So you complete the questionnaire, you give it to the attorney, you have a nice conversation with the attorney in which they explain to you that your stepchild is not actually a child, so they're not going to get the residue of your estate. They're going to tell you that your house is owned with your spouse as tenants by the entirety, therefore you can't decide who it goes to as long as your spouse is alive. They're going to tell you all of these things that you need to know based on how you've completed the questionnaire and what your specific situation is. Once you've made some decisions, then the attorney is going to draft the will for you, call you up, or send it to you by email and say, look it over for us. If any changes, go, and then we will solidify the documents by having them signed. I'm going to get to the signing of the wills in a minute because that's very important. But while we're talking about what you have and who you want to give it to, I thought it was important to mention, if you are married, if you have a spouse, or your state recognizes civil partnerships, any property that you acquired during that union is marital property. And if something, and I don't, this is probably in your state, but you have to check with your attorney. anything that you own. This dress I bought while I was married, when I die, it's my husband's dress. So will he want it? I hope not. But so the you have to remember that everything that you purchase during the marriage is marital property. And that's why married people sometimes like to have mirror wills. So they say the identical thing in terms of if I die, my wife gets it. If I die, my husband gets it. Everything except for these specific things I name. So the wills are identical. So the last person that dies, make sure that the last person who dies, their will control what's given, but it's going to reflect the wishes of the spouse because they were made together. You don't have to do that, but a lot of married people do. Now, what is not marital property that you can give away if you're married or not? If you have inheritances that you received, if you have a personal injury settlement, again, this is state specific, but if you were injured in a car accident and you got a settlement, typically that's going to be yours and not part of the marital property because you're the one that suffered that injury, not your spouse. So it's much more personal than a piece of property. Any property that you had before the marriage. So if you owned a house or jewelry or musical equipment, anything you owned before you got married, that's still yours as long as you don't commingle it. And what I mean by that is you get an inheritance, it's $50,000. You put $25,000 in an account that's in your name. You put another $25,000 into the household account, and then money gets drawn from that account, money gets put into that account. There's no way to figure out anymore what part of that 25,000 is yours and what's not. So once you mix it with your spouse's or community property or with your household expenditures, once you mix it together, it's no longer your private property, it's marital property. So if you get an inheritance, keep it separate. If you want to keep it and give it to somebody specific that's not your spouse. Also with premarital property, let's say I buy a house before I'm married, but when I'm living there, my husband builds a conservatory on it, he builds a wing, he renovates and landscapes the garden. That's commingling as well. So that's often unavoidable, but the longer you're married, the more it might be considered a marital asset. I think this is important that you know this. It's something that a lot of people don't know, so I wanted to mention it. Go. The other thing that's not part of your estate, I told you I'd get back to this later. It's not part of your estate and you cannot give it away in a will, and that is life insurance policies that you've named beneficiaries on, investments that have beneficiaries. So think back about if you have anything invested, was there a beneficiary? Go back and check, contact them and say, can I look and see who I listed as a beneficiary? Because you can put your estate, just put the estate, and then all that life insurance money or investment when you die will become part of your estate. But if you've left it to somebody specific or people specifically, then it does not go into your estate. It's not part of that residue we talked about. Yep. And I already talked about non-marital property that is not part of your estate. That all goes to your spouse. Next. Right. So the final steps are signing your will. That's very important. It's state specific. In Maryland, you don't have to have your will notarized. You just have to have two independent people sign it and witness your signature all at the same time. If you want to get it notarized, that's added assurances to authenticate the will, but it's not necessary in Maryland. That person cannot be a potential beneficiary under the will because it may invalidate that person's inheritance, or it may invalidate the will, one or the other. And then storage. When you're done with your will, wherever you get it, whether a lawyer, whether it's a form online or what have you, It's good to keep the original signatures in a special place. The one that's witnessed, with the original ink signatures, keep that in a safe place, and give a copy to your executor if you want. That's a good idea, so that they know specifically, or more importantly, if there's any funeral wishes in there, they're going to want to have it immediately after you pass away. But let your family know where you're keeping the will. And if you want to, you can record it at the Register of Wills in your state for a nominal fee, and then it's there. And if something happens, your family can contact the Register of Wills and ask if your will has been recorded there, and it's there for safekeeping. Finally, reviewing and updating your will after it's signed. These are the triggers that you should start thinking about. If you have a will, you haven't updated it in 20 years, you may not need to update it, but some people put in their will, I give my my Mustang to my nephew. Well, what happened if you traded in your Mustang for a BMW? Is that nephew going to get your car, or is that legacy negated because you specified Mustang? So those are some considerations. If one of your beneficiary passes away, you want to make sure that that your will is not going to turn into a situation where your will is voided because nobody's there to inherit it. Grandchildren, when you have grandchildren or new children, you really should consider definitely looking at your will again, because oftentimes in certain states, when you put something in your will, if the person isn't alive when you make your will, it's questionable whether that person is part of the category, what you intended to get, whether you intended that new grandchild or child to receive anything, because at the time you made your will, you didn't even know they existed. And if, again, with the substance abuse, if one of your beneficiaries, it doesn't have to be substance abuse, but if something has happened to them where they've become irresponsible, like I said, you might want to name a responsible person to hold on to that asset, and be discriminate as to when they give it to the beneficiary. Again, I'm just mentioning inheritance tax rules change. Can't talk about that because that's not something I do. Usually your accountant will be hopefully knowledgeable about that, if not your attorney. Yeah, and don't expect your attorney to contact you to make sure your will is updated. A lot of times they don't reach out. They don't want to bother you. So these are things that you need to be thinking about. If any of these triggers come up, then you need to pull out your will and dust it off and take a look at it. These are just items that you need to think about before you go to meet with an attorney, or before you start writing up your will. These are the things you need to write down that your attorney's going to know. Hopefully they'll all be covered in the questionnaire, but you want to talk about prior marriages, relationships, somebody that used to depend on you, somebody that used to take care of financially, but you don't anymore. Are they going to contest your will? These are just things to think about and to write down to discuss with your attorney. If there's any family conflicts, you should let your attorney know, because they can help avoid a situation where two people or people that don't get along are in combat over anything that's in your will. That's really not the legacy that you want to leave. And I've just seen that happen quite a bit. Your assets, you need to think about everything. Your cars, your investments, your bank accounts, your pension, any business interests you have, any charities you're volunteering with, your position with them. Is it important? Do you need to name a successor to take over your business or your charity? Any asset that you don't own all by yourself or that ownership might be in dispute of, you should write that down. And then you should know what all your debts or liabilities are, because you can specify in your will that you want out of your estate the debts to be paid off first before the distribution of the assets. And you can also forgive a debt that's owed to you as well. So these are just things to think about before you start writing your will. And these are the things that are going to be in your will if you want them to be. Specific gifts, the residue. And these are the things that you're going to include in your will that you should think about. And I think I've pretty much already touched on this, but again, it's your executors, guardians of your children, specific gifts, gifts to charity, pets, who should care for them, your funeral and your burial wishes, and you want to trust to protect or preserve your assets or your estate for the benefit of a specific person. We'll get to that in a minute. And anything unusual or different about your situation, you can address it in your will. You can be creative. Okay.
Before we go to this, I just want to take a second. I have 2 questions for you, and I want to see if anybody has any questions about the information that you've provided so far. But you had mentioned, well, first of all, I think this is such incredible information. And I think if we look at it as if it's not a sad thing to talk about, it's just business, it's personal stuff. It's the one act that you have total control over. And you're right, if you don't do it now, you're kind of out of luck. if you already pass, you just have to be aware of what's going to happen with things that were very important to you or any assets that you might have. So you explain what an executor is. So that's someone who's going to actually execute the information that you've put in writing and make sure that it's followed the way that you had your wishes. What's a personal representative? Because I've heard that term mentioned in a will before.
Right. They're usually used interchangeably.
Okay.
In our state, a personal representative is the person that you assign to execute your will, and the executor is, when you die without a will, the person that says, this person died without a will, I need to open up an estate at the Register of Wills, and somebody needs to be in control as the personal representative, but they didn't name anybody. So I'm going to be the executor. I'm going to take on that responsibility. And it can be any family member. It can be a friend. Somebody dies, they don't have a will. You go to the Register of Wills and you say, I want to open an estate. I'm their best friend. I'm their whatever relationship you are. You fill out the forms and you're the executor, as opposed to somebody that was specifically appointed to that position in the will. So, but people do use them interchangeably.
Okay. And you had mentioned something about debt. So I understand personal debt, you can have it stated that you want to relieve someone of a debt. But what happens with debt like your mortgage or your credit cards or medical bills? I'm sure is something that's of interest to the community. If someone passes and they have this incredible amount of medical bills or education loans, what happens with that? Who's responsible for that? Do you know?
Yep. So when you open the estate with the Register of Wills, you're required to publish the death in a publication specified by the Register of Wills. And then your state will specify how much time a creditor has to come forward before you can proceed to distribute the assets. So that goes for any of your debts. They become the debt of the estate. And they have to come forward. It's best to sort, if you know of a debt that's due, to get it taken care of rather than wait for them to come to you, because you don't want to end up in litigation. But they become the debts become the debt of the estate of the person that died. Well, you asked something else.
So it was about education debt, health, medical
Oh,
debt,
right,
right?
right. So that applies to that. When you're talking about a mortgage or a loan, um, if somebody dies, they're not gonna, you have to notify them as the executor, that this person has died, and they will either foreclose or somebody needs to get a new loan. They're not going to want to add you to the loan. They're going to want to re-underwrite the risk, and they're going to want to start a whole new loan with whoever um, owns the house. Otherwise, the house will have to be sold for that debt to be paid off. But mortgage companies know that, that they don't want to deal with foreclosing and all that. They'd rather um, be informed that somebody has passed away and have somebody else start a new mortgage or loan if the house is not going to be sold.
Okay. And if you had a credit card in just your name, not with your spouse added, how does that play into marital property? So if you
All
passed with debt,
property.
all,
So when I was in law school, I'll tell you this, when I took family law, every day of class, the professor, who was a very good family law attorney, every day he'd make the whole class recite, what is marital debt? All property, however titled, actually all assets and liabilities, however titled, that were acquired during the marriage. So your debt is your husband's debt. Um, your your motorcycle, your husband's motorcycle or whatever, your motorcycle is his motorcycle.
mhm.
It's all marital property if it was acquired during the marriage.
Okay, great. I just want to check to see if we have any questions or comments from the people who are viewing. Okay. All right, let's continue with power of attorney.
Right. Okay. So a power of attorney is something that you can download yourself. It's you can use an attorney, but every state usually has a standard form, um, and an attorney will add extra things in or tweak certain things or consider different things. But the forms themselves are usually pretty basic, and they're online. And that I gave you something to Google. So what I would do is Google whatever the year is and gov, free power of attorney form, and then your state. Because what first comes up is all of the websites that they want to charge you something for the power of attorney, and they'll say free power of attorney. So put gov in there and scroll down until you see something from your state. Is the best advice I can give you when looking for forms online, because everybody's going to try and charge you for something you can probably get free from your state. And a financial power of attorney is something that can be really handy if you travel a lot. So you can, it has to be notarized. You can stick it in a drawer, name somebody you trust. You can stick it in a drawer, you can give it to them. I'd rather stick it in a drawer if it's effective immediately. And then if you're out of town and something happens, there's an emergency, you can say, go get that power of attorney and sign this for me because I can't get there. Or you can say this is a power of attorney that's effective just for handling my car or just for handling the house. But a general power of attorney is going to give all the powers to one person. It can be revoked at any time just by putting it in writing. Again, check with your state.
Okay.
Oh, I want to say also, if the financial power of attorney deals with real estate, it may have to be recorded in your state's land records department. And again, that will be your higher court. So in Maryland, it's a circuit court. It would be the higher court of your state. Advanced Healthcare Directive, again, they're online. A lot of charities give them away free. And here's one, the Advanced Care Planning Healthcare Directives, that's from the National Institute on Aging. They have an Advanced Healthcare Directive, and you can specify if you want, if you're in an end stage condition, you can specify what support you want, whether it's just pain support or respirator, food, nutrition, or you can appoint a specific person to make those decisions for you, somebody you trust. But you can also say that whether there's a specific doctor that you want to determine if you're incapacitated, because the Advanced Healthcare Directive only kicks in typically when you are incapacitated and you can't make these decisions for yourself. Then the healthcare agent that you name will start either making decisions or stepping in to make sure your decisions on that form are followed. So if you have a do not resuscitate and on that form, and the ambulance comes out and tries to resuscitate you, but that person is in such a condition they don't want to be resuscitated, you will have to take that Advanced Healthcare Directive and say, hang on, no, here's my document. That's the document they gave me. They do not want to be resuscitated. Stop your life-saving procedure. So that's a really important document to have. And again, it's free. One thing I wanted to mention with regards to the heart, specifically, because this is aortic hope. Pacemakers and the like, things that are put into your heart, they're very expensive. They can be $20,000, or and up. They don't reuse them anywhere in the United States. It's not been given approval by the Federal Department of Health. But there are a lot of organizations that are taking them and working on getting these items to third world countries and people that don't have health care, because they're very, very expensive. So in terms of donating any of these, here's one that organization, myheartyourheart.org, and that is connected with a medical facility that's doing research and advocating for reusing these for poor people. So I just wanted to mention that. I'm not really going to get into what a trust is, but essentially tell you that when you say in your will that you want to trust, you can say in your will you want to trust, or you can set up a trust now. What it is it's taking an asset and it's taking out of your ownership, out of your ownership, and giving it to a trustee. They now own that, and they have to manage the trust, the money, the assets in the trust, the way you specify. They must do that. They have a fiduciary obligation for the benefit of the beneficiaries you specify. And one of the reasons people set up trusts is because means-tested benefits like Medicare and disability don't allow disabled people to have assets and collect benefits. So they're not allowed to get the resources that the government provides unless they exhaust all of their money, and that's not good. So you can say in your will, when I die, I want X amount of money to go into a trust, and it should be just for the maintenance and health of this person. And then that person doesn't own anything, and they can continue to get benefits. And then there's a trustee who's making sure that they get extras, that your money might provide for them. So just something to consider, that, it definitely need a lawyer for a trust, because there's certain language that you can include that, for example, if you say in Maryland that it's a spendthrift trust, then the beneficiaries' creditors can't come after the trust. And that's just magic language. So every state's different, but just be aware that it is a tool you can use to remove money from your estate for the benefit of a third person that's managed by somebody you trust. And that also means that you yourself, if you put your money in a trust, you can get means-tested benefits because you've taken that money and it's no longer yours. It's owned by the trustee. So just wanted to put that out there, that it's something to consider. And that just pretty much says what I just said. So that's the end of the presentation. If there's any questions.
So I want to check and just see if anybody has, they may be putting their questions together as we talk a little bit. I'm just found that so interesting. My mind is completely blown. I don't think I ever gave any thought to the pacemakers and defibrillators that are going in people's chest. I'm sure they're not reusing valves at this point, even though valves can last 10 or 15 years. I don't understand why it wouldn't be the same, but what an amazing organization for people to take that into consideration, to say, if something happens and here's an opportunity to at least send this so somebody can derive some use out of it. It just never even struck me, but that's now I'm going to be thinking about this all day. I don't have one, but I'm thinking about it for other people that actually
Yeah.
have that.
You just need to tell these organizations the forms are online. You just want to print them out and give them to the funeral director, and the funeral director will take care of removing it and sending it on for you.
That's amazing. Now, I just want to clarify also. So if somebody, I'm just going to use myself as an example. So I now just have my mom, and I receive disability checks because I'm on disability. So is it almost better for her to start those conversations about maybe establishing a trust with a portion of the money? I think what I heard you say is then if you receive money or inheritance when someone passes, then I don't get to have the disability payment anymore. Did I not hear that correctly?
No, I don't think you did.
Okay, I didn't hear it correctly. That's why I took a note and I put a big
Well,
question mark.
let me try and clarify your question.
Okay.
What is your question?
So what were you saying about being disabled and what happens in not being able to receive payments? You had mentioned something about that.
Right. So if you're elderly, you should be eligible for Medicare. If you're disabled, you're eligible for disability benefits. You're not allowed to have a big bank account. I think in Maryland, you're allowed to have maybe $2,000 of your own money, and that's it. So if you receive, $50,000 as an inheritance or wherever you get it, if you get it, you're not really allowed to get any benefits. Every year you have to requalify for the benefits you get typically. And once they find out you've got this money, because the banks report to the government, once it's known that you have this money, your benefits will stop until that money goes down to the allowable amount that you're allowed to have.
Okay.
So if the money's in a trust for your benefit, you're fine. You can still get those you can still get those means tested benefits that are there. I shouldn't say means tested. Means tested means means tested is you don't have enough money to get this benefit on your own, so you're not. So that's but it could be other criteria involved other than just how much you have. But anything that is means tested, you're not going to be able to have a chunk of money sitting in your bank account, and if they find out about it, they'll cut your benefits off.
Okay, that's good to know. So I think that for people in the community, the best place to look might be just to initially Google in their state if they feel that they have the assets and the residual items. If they want to move forward with a will, that they should just Google, and they could probably find these forms online, or go ahead and look to work with an attorney to help them put all of this together. But it's also extremely important to have that advanced directive in place. Now, once you create that, is that something you would recommend giving to your hospital system, since now so many hospital systems are connected through Epic or through these portals, and they can put it up there if they all relay to each other? Once that's created, what do you recommend with that?
They're not going to hang on to that. It needs to be presented. You can keep it at your doctor's office, I suppose, but it really needs to be presented by your loved ones. Take it to the hospital and or you take it with you if you go to the hospital. Anytime you're getting any care, end of life type care or anything like that, take it with you and give it when you get checked into a hospital. Give it to them, or if you're undergoing a procedure, give it to them.
Right, because I know they usually ask, it's one of the questions, do you have an advanced directive? And I sit there, I'm like, I don't have it on me, but I know I do have one at home. So that seems to be extremely important for anyone, let alone members of this community. And I think one of the things, my biggest takeaway is this is really no different than when we talk to community members about sharing their medical history with their loved ones. So if they're incapacitated, their loved one can at least say, hey, here's the medications, here's their allergies, here's this. It's having that communication and making things easier for those that are going to be providing care or those that you will be leaving behind in your absence. And it's just making things easier, and it's taking
Easier,
control.
yeah.
Taking that control for yourself. So I want to just check in and see if we have any questions. If we don't right now, it doesn't mean that we won't once people watch this on rebroadcast here. So is there any benefit to a living trust when handing down a home that's actually paid off? Did we lose? Think we may have lost.
Who did you lose?
Oh, are you still there, Susan? Okay, I didn't see you. Sorry.
No, I'm here
Okay.
thinking.
I lost you for a second.
No, that question is just so broad. I don't know what's in the mind of the person that's asking the question. It's almost unanswerable because you have to think about what your goal is. What is your goal? A revocable living trust in a lot of states, or I can't say a lot of states. In Maryland, is not going to allow the person that owns the house or asset to get means tested benefits because they know you can revoke it at any minute. If you want, in Maryland, if you want to have not a living trust or revocable trust, as they call it, if you want to have a non-revocable trust, after a certain number of years, it might be 5, I don't recall, then you can get means tested benefits. So again, that question can go in so many different directions. If you want to narrow it down for me, I'll try and answer.
So let me ask the question. I don't know if this is where their mindset is, but it's where mine just popped into. If you have a home that's paid off and you want to leave it to beneficiaries, is it better to put the home into a trust, or is it better just to outright just state the home goes to my beneficiaries? Is there options there?
Well, that is the question that was asked, and
so simple. Okay.
you just rephrased it a little bit.
Yeah, I'm just.
And so what? So I have to ask the person, "What's your goal? What is it you're trying to accomplish?"
Okay. Okay.
Is it better for you? I don't know. Tell me what your situation is, and I can tell you if it's good for you and your situation or not. So,
okay.
Unless if you live in Maryland, if not, you have to check with another attorney.
Right. Okay. All right. Any other questions? Okay. I think we've got all that information in 1 hour. I can't even believe it. That was amazing. And that is such great information. It's going to live on our website. It's going to live here on YouTube. And as we get other additional questions, I'll be sure to send them off to you so that I'm answering them correctly as the best of your abilities, depending on where the person lives. But thank you again so much for this, because as somebody I can openly admit that does not have a will, I can't believe it. You've given me a lot of so many different directions of things to think about. And you know what, I feel like I'm going to attack this now and not be so nervous or feel so emotional or feel so sad. I think what I started thinking as you were talking is, oh God, I have so much stuff. There's so much stuff. I'm going to have to broad spectrum figure out like how to put things in categories, or just say, let's just take one big broom and it all goes to one person and make it really easy. That's what I think is happening. I'm thinking, all the aortic hope, like, what are we going to do? There should be a succession plan with this and who gets what. Like, my mind's going to spin now, but in a way that's not emotionally charged. Like, I'm not writing these end of life letters. I'm making my final gift be ease. That's what I'm really doing. Right. And I'm control of it.
Exactly.
So,
you're very welcome.
Yeah. Thank you so much again for your time. We really appreciate having you. It was a wonderful presentation.
Thank you.
And thanks everybody for watching.